Contested non-probate transfers. Hello, my name is Richard Kim. Today is February 3rd, 2021. The title of my article that I will present today is Contested Non-Probate Transfers When the Estate Plan Trumps, published in 2020 in the California Trust and Estates Quarterly. The author of the article is attorney Matthew Owens. The conflict addressed in this article is non-probate transfers versus estate plans. To discuss this conflict, non-probate transfers versus estate plans, we will use the familiar framework IRAC: issue, rule, analysis, conclusion. First, issue. Can an estate plan, for example, will or trust, override a non-probate transfer? The issue is, can an estate plan override a non-probate transfer? Rule. Probate Code Section 5302 governs here. Clear and convincing evidence of a different intent documented in an estate plan instrument may override a non-probate transfer. Probate Code Section 5302. Probate Code Section 5302 indicates that intent may override title. Intent may override title. Probate Code Section 5302 is found under the California Multiple Party Accounts Law, also known as CAMPL, found in Probate Code Section 5300 through Section 5407. This Probate Code Section 5302 addresses three types of accounts: joint account, taught in trust, and POD, pay on death account. All three accounts allow for non-probate transfers. Probate Code Section 5302 allows for clear and convincing evidence, for example, found in a will or trust, to override the non-probate transfers using joint account, taught in trust, and POD, pay on death accounts. In addition, the clear and convincing evidence that may be found in a will or trust document may come after the account was created. The article presents 5 important cases that demonstrate the application of this rule. The first case is Plasencia versus Strazisic. Here, the issue is joint account versus a will. Ralph Plasencia had a joint bank account with an express right of survivorship to daughter Lisa Strazisic. But Ralph's will had clear statements that he did not want Lisa to have the right of survivorship. Ralph wanted the proceeds of the account to go to his trust. So what did the court decide? The court ruled that the joint bank account goes to Ralph's trust because there was clear and convincing evidence of a different intent found in his estate planning documents that indicated that the will should override the express terms of the joint account. And their governing rule that they used was Probate Code Section 5302. In addition, applying Probate Code Section 5303, they said that the bank should, however, still release funds to Lisa per the express terms of the joint account. However, the funds would then subsequently be distributed in accordance with Ralph's will. Second case, Areza v. Yonkin, taught in trust versus living trust. Here, Yonkin was designated as the beneficiary of a taught in trust in 2001. 4 years later, in 2005, the living trust named Reeves the beneficiary of that account. The court ruled that the living trust should prevail. So the living trust named Reeves the beneficiary of that account, therefore Reeves would be the beneficiary of that account. Again, they invoked Probate Code Section 5302 because there was clear and convincing evidence of a different intent found in the living trust, which overrode the express terms of the Totten Trust. Next case, estate of Hegstad. Here, the issue is deed versus trust. Hegstad listed a parcel of real property on Schedule A of his revocable living trust. But Hegstad did not execute a deed reconveying the property to himself as trustee of the revocable living trust. So he did not execute a deed. But the living trust had Schedule A, which listed the parcel of real property. The court said that the revocable living trust should prevail or should be followed even though the deed was not executed, because under Probate Code Section 5302 there was clear and convincing evidence of a different intent. So even though the deed was not executed, the wishes of Hegstad found in his revocable living trust should be followed. Next case, Ukstad versus RBS Asset Finance, Inc. Here, the problem was that the real property was not in the trust. Larry Jean Mabee Revocable Trust stated in the documents all of his real and personal property, wherever situated, should go into his trust. But 2 parcels were not identified in the trust. So you have an overarching statement that all of his real and personal property should go into his trust. However, he did not identify the 2 specific parcels. Court said that's fine. Invoking Probate Code Section 5302, clear and convincing evidence of a different intent. They said that the documents, estate planning documents, indicated that all of his real and personal property should go into his trust. And even though the 2 parcels were not identified, they would be part of the trust under Probate Code Section 5302. Next case, Cucker v. Cucker, stocks not in trust. So here, the revocable inter vivos trust had a general property assignment that said all property owned by me, both real and personal and wherever located, would be in the trust. In addition, the trustor signed a pour-over will leaving the entire probate estate to the trust. But there were a set of stocks, Medco was a company, that were not specifically mentioned in the trust documents. What did the court decide? Not a problem. Under Probate Code Section 5302, clear and convincing evidence of a different intent. Even though the Medco stock was not mentioned in the trust documents, the general property assignment that says that all property, both real and personal and wherever located, should go into that trust, indicated that that would include the stocks. So the stocks were lumped into were included into the trust. Conclusion. Conclusion, number 1, first, estate plan, will or trust can override a non-probate transfer. So an estate plan, for example, will or trust can override a non-probate transfer. That's the most important point. The governing law is Probate Code Section 5302. And the key term here is clear and convincing evidence of a different intent. That allows an estate plan instrument such as a will or trust to override a non-probate transfer, and this includes joint account, Totten Trust, and POD, pay on death accounts. What did I learn? Most importantly, non-probate transfers may be contested. This is a very important point. Statutes and case law govern, specifically Probate Code Section 5302. So this is statutes and case law here. In terms of estate planning, estate plans should be complete and consistent, and unless it's a very, very simple estate, I would recommend that consultation with an attorney would be wise here. Now, after the decedent passes away, the trustee, executor, administrator whoever is responsible for handling the distribution of estate, they may need to consult an attorney to make sure that they are performing their duties properly. So non-probate transfers may be contested, so the trustee should look for that potential challenge. And these are situations where a probate court may need to review the particular issue. What would I change? In reading this article, I saw that there were some areas of improvement for the probate code. So I would recommend revising the probate code statute, specifically to clarify, elaborate, and expand on common scenarios that arise. For example, in the case where a trust or a will says that all property, real and personal, should be transferred in a certain way, for example, all stocks, but does not specifically identify the stock, that is a scenario that the probate code could probably address. So clarification, elaboration, expanding to different common scenarios, I think would be beneficial because they would help with conflict resolution, and they may actually help prevent conflicts when you have non-probate transfers and then there is an estate planning instrument, for example, a will or a trust, that conflicts with that. So this would make the execution of the estate plans after the decedent passes away run more smoothly.